Change change is the law of life, and those who look only to the past or present are certain to miss the future. This quote by John reminds us that change is inevitable and that we must embrace it if we want to succeed in life. It also reminds us that we should not dwell on the past or present, but instead focus on the future and what it holds for us. This quote is very relevant to today's program as it is all about learning new things and embracing change expected in the future that is related to the psychiatry. Good morning, everyone. I am Dr. Atul Dhage, consultant psychiatrist and owner of Mind Care Hospital for Mental and Sexual Health, Ratnagiri, and I am honored to be moderator for today's program. We are here today to attend an online program which is organized by Legal and MHCA Committee of the Indian Psychiatric Society, Western Zonal Branch. The program will have 4 sessions of half an hour each. The program will cover topics such as challenges in running a uh, private psychiatric hospital, record keeping and certification, digitalization in psychiatry practice, and uh, insurance and professional indemnities. And this will be conducted by Dr. Mahesh Gowda sir, Dr. Sanjay Kumar sir, Dr. Nimesh Desai sir, and Dr. Harish Vadlamani sir, respectively. I hope you all will enjoy this program and you will learn many things, new things today. Before we start the program, I would like to invite Dr. Umesh Nagapurkar sir, President of Indian Psychiatric Society Western Zonal Branch, to address us.
Thank you,
Dr.
Dr.
Umesh.
Atul. Thank you, Dr. Atul. I welcome you all to this today's interesting program on legal challenges, legal Spiegel, that Dr. Hemant has coined a very good term for this. I thank all the speakers, Dr. Mahesh Gowda, Dr. Sanjay Kumawat, Dr. Nimesh Desai, and Dr. Naresh for accepting our invitation and at a short notice and on Sunday morning in their busy schedule, they have taken out time to address us. And I think this is going to be a very enriching experience for all of us because legal challenges are on rise in practice. And we would like to help our colleagues, ourselves, with knowledge shared by our esteemed speakers. I thank Dr. Hemant and legal subcommittee of West Zone for arranging this kind of program. And we will have similar programs in future also. Thank you very much. Over to you, Atul.
Thank you, sir. Thank you very much. Now, I would like to invite Dr. Dhananjay Astorkar, sir, Secretary of Indian Psychiatric Society, Western Zonal Branch, to address us. Dr. Dhananjay Astorkar, sir.
Thank you, Atul. Wish you all very wonderful morning, Sunday morning. Friends, few days back, maybe 2-3 weeks back, my beloved friend and very enthusiastic coordinator of legal committee, EC member Dr. Hemant called me, and we discussed a lot about the how to go ahead with this all this program in the future. One thought came in the mind that we are having so many lectures and so many seminars on MSCA, but why should not having some topics which have a importance irrespective of MSCA? Means whether MSCA implemented or not, that is a different issue. But these few things which are very basic and every psychiatrist or every doctor should be kept in the mind while practicing. So we thought about these few and wonderful lectures. Those are now related to the legal challenges in running nursing home, like insurance, like record keeping, like digitalization. And so we thought that we can have a short CME of two compact CME of 2 to 3 hours on Sunday morning. And this is today is that Sunday. Thank you, Hemant, and all members of the legal committee for having this program. I thank all speakers for their contribution. There is no doubt seeing the names. It will be a wonderful program, and which we definitely West Zone is committed for to conduct many various and innovative program in the future also. Thank you, Atul. I wish you all the best.
Thank you, sir. Thank you very much. I'm sure many of us have our psychiatric nursing home, and many of us might be facing or thinking that we may have to face certain issues in running psychiatric nursing homes. And we have our first speaker who will address this issue today. Uh, Without much ado, I will much taking your time. I would like to invite our first speaker of the day, Dr. Mahesh Gowda. Who will be talking about legal challenges in running a private psychiatric hospital. Dr. Mahesh Gowda has completed his MBBS from BMC in 1999, DPM from NIMHANS in 2002, DNB in 2004, and he has set up a rehabilitation center in 2001 itself. He had received a DLN Murthy Rao Award for Best Outgoing Student in NIMHANS. Then he is currently working as a consultant psychiatrist at Spandana, and he is director of Spandana Healthcare. He is also DNB program coordinator at Spandana. He is direct council member of IPS, past president IPS KC, and past treasurer of IPS. He had almost 70 publications in the Index Journal. I invite Dr. Mahesh Gowda to give his talk. Over to you,
Thank you,
Mahesh Gowda, sir.
Thank you, Dr. Atul, for the introduction and setting up the topic for me. I thought I will spend a few minutes on actually the legal aspects that happen and keep talking about case vignettes that actually are of clinical relevance to us when we are running this hospital. Next slide, please. So when we are looking at psychiatric practice and we are working in a setup, there can be multiple interfaces that we are going to get into. So this can be criminal cases, this can be civil cases, this can be NMC regulation and violation related cases, and also related to MHRB related cases. So a single case can actually have doors to knock on in multiple forums. For example, I am a newcomer. I would have admitted a hospital in an establishment that is not recognized as MHE by the state mental authority. Is a case of suicidal behavior on the background of severe depression. And when I admit here, I don't have facilities for ECT and I'm trying medications here. So this patient apparently escapes and leaves the hospital and goes outside and falls on a railway track to kill himself. So a case like this, I can be tried under criminal cases for medical negligence. I can be tried in the consumer forum for compensation related issues. I can also be tried under NMC regulations and the State Medical Council ethical violation related issues. And I can also be penalized by MHRB. So a single case can have multiple dimensions, and that's how psychiatric practice is becoming more legal than just clinical issues. Next slide. In looking at medical negligence, most of the time doctors are actually booked under 304A of the IPC, which deals with death of a person by rash negligent act leading to death. And this also entails imprisonment up to 2 years' time. So recently, I was under this 304A IPC case for a patient had tried to escape from the hospital. He had fallen down, broken his bones, multiple fractures, and he had died. So I had a 304A on me, and the High Court squashed his proceedings just 2 months back. So it's not very difficult to get into cases. It's beyond our hands. Sometimes we get into trouble like this. They also use sections like 337 causing hurt and 338 when it's grievous hurt also. And these are actually imposed along with 304A when medical issues of negligence arises. Next slide. Coming to civil liability, the consumer forum laws are very strict, and the lot of activations happening from the patient side. I'm sure this is not the scenario 10 years back, but now every other failed case of treatment and dissatisfaction lands up in a consumer forum for the compensation purpose. The recent revision of the consumer forum laws says that a district forum can try cases up to 50 lakhs. State forum can try cases up to 2 lakhs, and anything beyond 2 lakhs, 2 crores, sorry, 50 lakhs to district forum, up to 2 crores for the state forum, and beyond 2 crores, it goes to national consumer forum. So anything which is actually a dissatisfaction arising out of poor consenting or not following a particular guidelines can land up as a civil suit in the consumer forum laws. So here there's importance that we understand that we have to follow guidelines and practice, which could be a standard as per any treatment guidelines or as per the society recommendations at least. IPS has clinical practice guidelines, and that's the best way to keep ourselves updated and follow whatever is expected from IPS guidelines. Next slide. So here we have two tests that we have to remember when we are going to the consumer forum. One is a Bolam test. All of us know about it. Medical profession, the skill of each practitioner differs, and there's more than one modality of treating a patient. We can choose some other treatment over the other treatment, and there's a lot of variability here. So what Bolam test does is, a doctor is not negligent if he's acted according to a practice accepted as proper and reasonable by a professional body skilled in that particular act. For example, if IPS says that severe depression ECT has to be given, and if you have given ECT on this sort of background, it is acceptable, and we are not considered negligent. The judiciary felt that this law was actually one-sided. Most of the doctors can get together and say that this is what they want to do, and finally we can easily pass Bolam test. But there's another variant. If IPS has a stance on a particular case scenario, IAPP can have a different scenario and different stance there. So there can be variable opinions in the medical professional bodies itself. So the next test that is going to be talked about is Bolito test here, where there's an amendment to the Bolam test, and it is actually clarified there what is a reasonable body. And if at all there is a difference in the opinions of two reasonable bodies, it has to pass to the logical basis test here. So if the court does not understand that there's a logical basis for any decisions, I think it will set aside, and it takes to a logical scrutiny of the current scenario, and the Bolam test is not valid in this sort of scenarios. Next slide. We have the new regulation, which is around 9 to 10 days old. It's been approved and gazetted. So we'll have multiple regulations that will be in conflict to whatever we are doing right now. It could be prescription of generic molecules. It could be the way we conduct ourselves, our interaction with the pharma, the CPD conduct. So there are various interfaces where a doctor and the NMC regulations can be eroded, and we have various punishments and liabilities that we are going to get into here. Suppose we are practicing in a state where we have not registered ourselves. Now NMC is going to come up with a national registry, and we have to register ourselves in the National Council, but we have to take state licenses. Suppose I have not taken a state license, it will amount to a breach of professional misconduct, and they can also charge monetarily. Till now, there's no monetary penalties, but we're going to have 10 times the monetary penalty of the license fee in case we are found having misconduct related issues. They've also defined what each level of breach of L1 and L2 could be up to L4. Next slide. So in case there's a false complaint and the medical council finds that there's no case to try on us, we may be exonerated. That's the best possible scenario. In case there is any evidence to say that we had breached certain amount of provisions, but may not be amounting to any harm or hurt to any patient here, they may suggest reformation here, ask us to go through CPD training, ask us to take additional CME points. They can ask us to attend specialized workshop. They can just issue a warning in future, or actually ask for change in the way we display our names and things like that. So this could be just a reformation. Next slide. Level 2, level 3, level 4, based on the amount of breach of the professional code of ethics that we have, the suspension could be up to 3 days, up to 3 months, or up to 3 years. So this is what is in store for us in case we are actually not following the NMC regulations as per the prescribed norms. Next slide. Another important aspect here is we are going to deal with MHRB, whether we like it or not. It's been implemented, and in our state, it's a very active MHRB. We're already getting a lot of letters for clarification, asking for data periodically, also getting oral warnings now for any sort of data not being submitted. So in case I'm practicing in an organization which is not a registered MHE, I can be fined up to 25,000 rupees. For a repeat offense, it can be again compounded. Only OPD services and Section 94 emergency services are exempted from registration. The rest of the things come under the purview of registered MHE only. And we have to keep sending data as per the norms that he has submitted. Suppose we don't send the data, we have penalties from 10,000 up to 50,000. It can go up to 5 lakhs. So based on the breach of the provisions of MHRB, we have various penalties that we are going to get into. So it's also assumed that ignorance of the provisions of law will not stand the test of defense, and we are expected to know and follow as per the stipulated norms of the MHCA, and also be constantly interacting with MHRB to make sure our practice is quite legal and acceptable for MHCA standards. Next slide. So psychiatry and legal interface can happen in multiple phases. Recently, I got a inquiry from the police. This is the case we had treated, and this patient was a case of F20, and she had stopped treatment, not followed up for 1 year. She was a teacher. She's actually smothered and killed her 6-year-old daughter. She was off medicines and she was in a relapse. So they want to understand whether this patient had illness, what was the diagnosis that we were treating for. They wanted the records of this patient. And so that's how we can get involved in an investigation, whether we like it or not. The court also can keep summoning us for various things on deciding whether the patient is having fitness to stand trial. Marriage and divorce-related issues, very common. Called as an expert evidence on these sort of matters is a very common scenario. Whenever there's a patient or family dissatisfaction, that can serve as a nidus for further legal complications. We also deal. Hello? Yeah, we also deal with multiple regulatory bodies here. So we have the MHA license, we have the municipality licenses, we have the state Clinical Medical Establishment Act licenses, we have the Pollution Control Board, ESI, Provident Fund, Fire Department, the human rights groups and NGOs that serve as a constant regulatory body for all of us. Next slide. So we are having difficult situation basically because of the subject that we are dealing with. So we have patient-specific issues where we have escapes, non-consent issues, particularly whenever it comes to substance abuse criteria. We have death and declaration-related issues. We have admission under Section 86 and exploitation. Recently had a patient who said that he is Section 86 because he was in a capacity to decide everything. He actually got himself admitted, but he had actually come here to seek referrals for actually supporting his addiction chain. So he wanted clients to, and he had come to recruit in our center the opioid and the cannabis addicts. So he was trying to talk to them and take their phone numbers and things like that. So Section 86 also can be exploited in multiple ways. We also have disease-specific entities where we deal with patients who have no insight, aggressive and deceptive behavior, violence towards staff and others, suicide attempts and disinhibition. Next slide. Next slide, please. Yes. So I thought I'll deal with 3 basic challenges here: the violence, the suicidal patient, and absconding patient. Next slide. So here, at times we enter into a very gray area here on violating patients' rights. Here, there is a necessary violation that's called for here. They can be at danger to self, others, destroying property, and at times involves emergency intervention to make sure we use restraints. So whenever there's a restraint, we must understand that it has to be authorized according to law by a psychiatrist, monitored periodically, for example, every 10 minutes or 15 minutes, and documented evidence to say that this is actually authorized, the rationale for authorization and the monitoring and safety process taken up is what we must remember. All these things are going to be standing the test of scrutiny by the Mental Health Review Board, and we are bound to send updates to the board on a monthly basis on the restraints that we're going to use. So right now, when we're talking about restraints, it could be physical restraints, but if they expand the horizon and say chemical restraints also needs to be documented. So we'll have multiple documentary related lapses that happen. So we have to maintain separate registers. Next slide. Next slide, please. So coming to suicidal patients, the death in a mental health establishment by suicide is not a very uncommon thing. Sometimes it happens in spite of all the best measures that we take. We can have CCTV surveillance. We can have attenders staying within multiple throughout the 24/7 time. We can have a lot of precautions that we do where we take away access to medication, sharp objects. We can keep the doors preventing from locking and also take away the fans and do a lot of monitoring, but still we may end up having a suicidal patient. Next slide. Next slide, please. Yes, so we'll have to recognize patients who are at high risk. Make sure we are using early assessment and interventions like ECT, a lot of documented practices to say that we are taking all the required safety planning whenever it's appropriate, and also using the required instruments in assessment of all this sort of risk liability that we're going to get into. It's also important to convey important information about this sort of risk to the patient and the families involved, and make sure the ultimate potential of suicide is actually mitigated. Next slide. Next slide, please. Yeah. So we also have absconding patients. We have people under Section 86 who leave the hospital from the premises without completing the discharge formalities. So it's not considered as an escape or absconding patient at all. In 89, we have some additional liabilities because we admit them, they're incapacitous, and we're keeping them against their wish. Sometimes they're against their wish without an attender and a person to take care of them. So hospital takes on a lot of responsibilities, and we end up in situations where these sort of patients leave the hospital premises and actually abscond. So they're actually not under any judicial inquiries, or they're not prisoners under trial. So only prisoners under trial needs to be reported to the police station to register FIR and to help the police to trace these sort of patients and put them back to the mental establishment. The Act is silent on absconding patients related to Section 89 or 86 here. So we have to make sure we employ all necessary protocols to make sure we use adequate pharmacotherapy, use restraints, use ECT whenever there's a need. Make sure we strengthen the hospital security, adequate personnel, sophisticated gadgets for raising alarms also can be used. And make sure also we have timely discharges in case we know that this patient actually may leave the premises and abscond. I think it's good to consider timely discharge in case we are not able to make a difference to certain patients. Next slide. I thought I'll talk about case scenario. This is Mr. A, who a 52-year-old chronic EDS patient with chronic liver disease. He was in very bad shape. He didn't survive in. Sorry, there's some disturbance in between. So the family thought that he's not going to survive each hospitalization he had been to, and probably we were the 20th hospital for seeking long-term care here. We did everything possible to make sure the patient was stabilized, but ultimately he had excessive hematemesis and he collapsed. We did everything possible to make sure we tried our best to stop the bleed, and also make sure he was referred to a nearby hospital for banding of procedures. We did CPR and he was revived. And finally, because of the loss of blood, which was too much, he actually succumbed and he died. The family was happy looking at the sort of evidence that we had on CCTV for whatever we did. But the extended family was unhappy, thinking that we did something to kill this patient. And so it actually went to finally autopsy because they didn't know what was happening. And it's good to make sure we take all possible help in the legal scenarios available. Any case that you're not comfortable with, any case the family actually makes some allegations, make sure autopsies are done to make sure the cause of death is ascertained. Next slide. This is also another case where it's a 28-year-old girl who was admitted on the background of severe depression with high suicidal risk, and she was already on modified ECT, thinking that that was the best way forward. But she attempted suicide in the hospital using her leggings as a rope, and even in CCTV footages, she appeared to be just standing on the floor, and it actually did not really aid us. And the family was not with the patient, and the patient was staying alone because the family had some important event and they had gone home on a permission to actually come back the next day. And we lost this patient. And again, CCTV evidence is the only thing that we had to explain in all the required precautions that we had taken. Next slide. So a lot of challenges can come from the family itself, just not the patient most of the time. So we have issues of abandonment of families, non-payment of fees, issues with guardianship, issues with marriage, bank and property issues. I thought I'll spend 1 or 2 minutes on each aspect of this. Next slide. So families, due to their social circumstances, just admit and keep paying fees. Sometimes they don't come back. We have a inbuilt system in the MHCA where we as psychiatrists are responsible for planning the discharge of this patient, and the discharge planning happens on the day one until the patient is actually rehabilitated in the community. This discharge planning keeps happening. So sometimes they pay the fees, sometimes they don't pay the fees. It can be a huge economic burden on the MHE also. And discharge of these patients cannot happen because sometimes they're under Section 89 or 90. So ideally, stabilizing them and putting them on Section 86 and considering timely discharges is very important. It's an onus on us. So not having adequate discharge plan can amount to violation of patients' rights here. Next slide. The financial difficulties that we may get into, these are all civil disputes. So patients, the family may pay advances and not come back, not pay the rest of the commitments that they have. They have sometimes irregular, staggered payments. We have check bounce cases. They keep insisting on discounts. See, the best way is just admit the patient. You have a bill which goes up to 50, 60,000. Then they sit and bargain with you and say that we'll pay 20,000, 30,000. They ask for discounts. The only way to recover this sort of money from the client would be you have to initiate a civil suit. So sending a legal notice would cost 10,000. And if you put it up as a civil suit and pursue and finally win the case, you will end up spending 50,000 to a lakh rupees for this sort of suit. So the actual patient bills can be much lesser than this sometimes. So it is actually practically not possible to initiate any sort of civil recovery suits on patients and family who don't actually pay the required fees here. In spite of having adequate financial contracts, they actually default. So this is the reality of running a mental health establishment. Next slide. Issues of guardianship, you have limited guardianship and the permanent guardianship that's allowed by the RPWD Act. So a lot of times family requests us to certify these patients for limited guardianship or sometimes total guardianship. It's ideal that a board does it, not an individual psychiatrist, because we can get into multiple complications here. There are adequate provisions in the MHA to ensure safety of this sort of mentally unwell patients, and nominated representatives provisions also covered under. But for guardianship, I think we have to go back to RPWD Act to make sure we give a case for providing guardianship here. Next slide. With the new MHCA, also what's going to happen is abandonment is going to be also common, because the law does not give any sort of rights to the family. The patient interest and well-being is the most important thing. So paying the patient and taking care of him, and we have a non-consenting patient and patient is not cooperative. So abandonment is actually going to be very common with the new provisions of MHCA. The next issue would be the marriage. So if we treat an unmarried male and unmarried woman, most probably we will end up in a legal case here, sometimes simply because I've been losing hope on the marital prospects of people who have mental illness, simply because sometimes they conceal and get the person married, and eventually it lands up in a separation suit. In case you're informed also, sometimes within 3 months or 1 year of marriage, sometimes the equation changes. And if the patient is seen in a relapse during the first 1 year of marriage, most of the time it leads to separation again. As psychiatrists, I think we have a lot of responsibilities here to make sure we explain the pros and cons of marrying a person with a healthy individual, marrying a person with another person with mental illness. Genetic counseling aspects also have to be addressed, and I think we have to give a balanced view on all these aspects here. And we should not divulge any information of the mentally ill person without the consent, which could be written here in this case, simply because oral consent sometimes can be denied. If it all be divulged, it will amount to violation of person's rights, and that also can be a cause for complaint to MHRPC. Next slide. Bank and property transaction, a lot of times we only do capacity to consent for treatment. So sometimes we will end up doing capacity for legal capacity assessment and also financial capacity assessment. Preferably, somebody who's admitted in Section 89 is preferred not to go through any financial transaction, because we will be dragged into it, and sometimes we wouldn't have done adequate assessments to certify in this sort of cases. So just prohibit them from doing any financial transaction during Section 89 admissions when they're otherwise incapacitated by assessments for treatment purposes. Next slide. We have the foreign nationals NRIs coming for treatment, and we have an obligation to report to the FRO office and also report to the embassy here. So we have to give them a copy of a valid passport, the diagnosis, and also the visa status of this patient. So if at all we don't treat and something treat them, and if we don't inform them and something goes wrong, we get notices from the police for non-information to FRO office also. Next slide. I think it's important that we are more proactive in preventing medical legal issues. So we must have adequate documentation, have adequate opinions, second, third, fourth, if possible, adequate consents, use all relevant forms for sectioning. You must be in tune with MHCA 2017 and communicate with MHRB on a periodic basis. Keep family members during admission for safety. We must also liaison with law enforcement agency and take help whenever needed. Next slide. We'll have multiple licensing issues, so we have to make sure our softwares and the IT purpose that we're going to get into also is according to the IT Regulations Act. We also have to register ourselves as a venture or a company or the society for IT purposes. So we need a trade license, we need a MHCA license, we need a pollution control board license, fire compliance issues, and also NOCs from adjoining neighbors. We also need the Clinical Establishment Act license. So all these things are interfaces where if you don't follow, all these things can be denied us for a legal action on us. It may just begin with a notice or further action can be initiated on us. Next slide. If you're running a pharmacy, you may need the pharmacy license, Schedule X license, opioid possession and sale. You know what actually happens in spite of the best of the norms followed in Rajasthan and Punjab. Doctors keep getting into trouble. So sale of opioids is under strict monitoring. And I think we must have adequate documentation and consents in place there. Biomedical waste disposable, we also have notices from the organizations when we don't follow the norms. So we need a separate lift license, generator use license, canteen license, CSIPF, and multiple other issues that come in. Next slide. So admission is no more a shared decision-making model between the patient, family, and doctors. Here, the patient-centric approach is the only thing that's going to sustain the test of time here. And capacity to consent becomes the primary concern here. And we have to assess capacity adequately and make sure all decisions are based on the patient's capacity, and all the other things become secondary. MHRA intimations and all the Section 89 admissions for approvals of Section 90 admissions is all important. Giving modified ECTs for minors also should happen only with the permission of the MHRB. Please don't venture into this area at all. Next slide. Next slide. Next slide. I'm just skipping these slides. So discharge planning is something that's been bestowed on the psychiatrist. I don't know whether we really wanted it, but a lot of emphasis is put on the treating psychiatrist to make sure the patient is treated adequately and also restored back to the community. And the discharge planning happens from day one. So we must document adequate attempts for formulating a good discharge plan. In case there are hurdles identified, please mention the hurdles and what prevents the discharge, because it's the only thing that can actually be in our favor when the MHRB scrutinizes each patient's admission and treatment. Sometimes the patient ends up staying for a few months, and even with approvals of Section 90 and extending up to 6 months also, we must be clear in our documentation to say why this patient needs to stay here, and it's for treatment purpose and not only for psychosocial reasons or for lack of rehabilitation facilities elsewhere. So there should be a case for treatment in a mental health establishment. That's the only thing that's going to stand the scrutiny of the MHRB. Next slide. We also have newer documentary practices that we need to adapt here just to make sure that there are going to be a lot of applications for basic medical records. Our records must be in tune for the OP and IPD divisions. We'll have independent admissions and also court admissions of minors. So all these things has to happen on specific requests in the prescribed form. Any discharge request also should be in the discharge form. Any request for information should be on a particular prescribed form. Leave of absence should be on a prescribed form. Information to the police of any unauthorized absence of a prisoner from MHE is also in a prescribed form. For a person who's not under trial by the court and who's not a prisoner, there's no authorized forms there. We need to also make sure our records are stored adequately. A good practice could be to store it for 3 years for OPD. IP, NMC is clear, it says 3 years. Medical legal case, indefinite, what it says. So we need to have an SOP by the professional body, or to make sure till such something things happen. It could be 3 years for OP and IP records, and digitalization is also mandated. by the NMC regulation now. So we must all work towards digitalizing, and I'm sure my colleague is going to talk more on digitalizing records. Next slide. I think we'll have to do everything to make sure we don't enter into conflict with law here, and we practice everything which is NMC, MHCA compliant. In spite of being compliant, dissatisfied patients can seek remedies under consumer forum issues. The only thing that we can do is do everything to prevent litigation here and work towards a compliant, legally binding system of practice that can protect us at times of scrutiny. Thank you so much.
Thank you very much, sir, for your wonderful insights. We will take 2 or 3 questions, possibly. First question is it mandatory to prescribe generic drug, or can we write branded drugs?
I think if you look at the NMC regulation that came in, it is mandated all of us, including people in medical college and private practitioners, to prescribe generic molecules. But it also authorized us to dispense or sale of medications without having a pharmacy license. So it's a very thin line here. You can prescribe generics and dispense medicines that is suitable to the patient also. So the new provisions makes it legal entity. It could be challenged later by the pharmacy council, but right now it's a legal entity that we can sell medicines to our patients.
Sir, second question is, should we write provisional diagnosis or diagnosis on paper while prescribing?
If you look at the NMC regulations and ethical concerns that we have, if you don't have a diagnosis, you cannot prescribe medicines, is what it says. It's good to document a provisional diagnosis and then only prescribe. If you don't have a definitive diagnosis for OPD management, you can suggest inpatient care when you don't have a definitive diagnosis. But mentioning is a good practice, because that's also mandated in the prescription format to have a diagnosis there. Dr. Atul?
Sir, for OPD, do we have to register under MHRB?
Sorry, I didn't get the question, sir.
Sorry, if we have only OPD consultation, do we have to register under MHRB, sir?
No, sir. OPD and Section 94 treatments are exempted from registration, but anything that goes wrong comes under the purview of MHRB.
Okay, thank you. Thank
you. Of MHRB.
We will be taking the last question. After MSCA, the addiction centers and old age homes where dementia patients are kept, and where should be dementia patient kept, are under ambit of law. I think Balchandra Kalmek, you can unmute yourself and ask the last question.
Sir, what is happening after this law? The addiction centers and old age homes are coming under MSCA. But these centers are not registered. So can we visit them as a visiting psychiatrist? Or can this patient be brought to our OPD for consultation and we just do OPD consultation?
Yeah, so what is safe here is to make sure all centers, whether de-addiction, geriatric centers, if they have access one and treating them for this sort of purpose, should be under the purview of registration of MHRB. Suppose you have to go visit the centers, you will be inviting a penalty for visiting and serving as in the capacity of MHP there without registration, and you can have a fine of 25. So seeing them in your clinic or seeing them in outpatient part of the department where you don't know or you claim ignorance that they were admitted, could be a gray area here, and you may escape the scrutiny of MHRB here. But if you see them on if you look at the seriousness of the MHCA regulations here, all centers treating people with mental illness should be under regulations, what they say. But yes, seeing them on OPD can be a saving clause for us.
Yeah, thank you, sir.
Thank you very much, sir. I once again thank you. Now we'll move to our second session. One of the best thing about Mental Health Act 2017 is that inclusion of various mental illnesses under the insurance policies. So to talk about this, I would like to invite our next speaker, Dr. Sanjay Kumar sir. He will enlighten us about health insurance and professional indemnity. Dr. Sanjay Kumar sir has done graduation and post-graduation from GS Medical College and KM Hospital, Mumbai, with over 30 plus years of experience in psychiatry in general and community and legal forensic psychiatry in particular. He was he is former deputy director at Government of Maharashtra, former medical superintendent at Regional Mental Hospital Thane. He was former member secretary of State Mental Health Authority, Government of Maharashtra, and past president of Bombay Psychiatric Society. Presently, he is director of Insight Mind Care Center, and he is consultant psychiatrist at Jupiter Hospital, Fortis Hospital, and Hiranandani Hospital at Thane. I would like to invite Dr. Sanjay Kumar sir to share their insights on health insurance and professional indemnity.
Well, good morning, everyone. Talking about mental health insurance, I'll give a brief introduction and brief insight about the mental health and insurance issues, the challenges faced during that. And then I will switch over a brief talk on professional indemnity, particularly from mental health perspective. So coming to the first slide. Next, please. As we know, there is enough kind of discrimination done between physical health and mental health. Enough considerations on rapidly increasing physical health complication in India due to various reasons. But there is a particular need to protect people with strong insurance system, providing them financial security against variety of illnesses. And yes, mental illness is one of them. As per WHO, there is hardly any space for mental illness coverage. If you see the gravity of problem, almost 90 million Indians, or around 7.5% of country's population of 1.3 billion, suffer from various forms of mental illnesses. 42.5% employees from corporate in India suffer from depression or anxiety disorders. That is every 1 in 3 employed. The online queries for psychiatric help, particularly during that COVID pandemic, 50% in first 2 weeks of lockdown, and that to the young productive population group, 21 to 31 years. The online queries from mental health issues grew 180% in those 6 months of COVID-19 pandemic. Next, please. Criteria which influence the insurance claims. The age of the person. The age of the person, because various illness arises during that particular age, as during the entire spectrum of the human lifespan, that is from childhood to the senior citizen's age. There are multiple kernels and multiple ranges of illnesses which arise. At the same time, the illnesses also, as per the age, takes different course of time, and it may add comorbidities to it from mental health point of view. The right combination of premium and coverage here is the most important thing. The waiting period clause, that is from onset of purchasing the premium policy and the onset of the illness. Cashless hospitalization benefits, pre and post hospitalization coverage, maternity coverage, because this will be very sensitive information about patient having maternal illness, may not get complication, but suddenly he may land up with some kind of psychiatric illnesses. No claim bonus or no claim discount. This is as per regular policies. Preventive health checkup facility. Now, preventive health checkup facilities may give you some kind of clues in form of the personality profile, but that can not get added as a diagnosis. The co-payment clause, that is between the company and the insurer, and the claim purpose for which it is been claimed. Next, please. Now, as per the Mental Health Care Act 2017, the mental illness is very clearly defined as something to protect, promote, fulfill the rights of such person during delivery of mental health care and services for matters connected therewith or incidental thereto. We have a clear-cut definition of mental health care, which includes analysis, diagnosis of person's mental condition, treatment, care, and rehab. The mental illness, what is being defined under the Act, is different from what is clinically defined as per WHO or other classifications. So as per the mental illness definition in Act, the mentally challenged people are excluded. Substance abuse disorders which are plain without any kind of psychopathology are excluded. Capacity is very important in such case, and capacity decides multiple things in this particular Act. The Act, as I said, doesn't include the subnormal conditions. Next, please. What are the challenges for insurance providing companies with respect to the Act? The first and foremost is the mental illness definition, which is there are no clear-cut guidelines by IRDAI, that is the regulatory authority of insurance. The variations in clinical definitions from clinical to the Act legal definition. Alternatively, primary bipolarity patients might get engaged in impulsive substance use or sexual behaviors and then land up with medical complications like HIV. This is not taken, or this needs to be taken, is a major issue for the insurance company. Variation in interpretation, coverage offered, and the insurance claim. As the insurance, as the public awareness about the illnesses go up, the burden on the insurance company will increase because there will be more claimant for the same. The comorbidities, disabilities, mortality rates, cost of treatment, poor compliance issues, plus variety of the comorbidity, mental illness and physical illness, plus the additional risk conditions may further needs to be taken into account. Insurance may or may not provide it for certain comorbidities, despite one of them fitting into the definition of mental illnesses. To give an example, diabetes plus hypertension plus dementia, what it comes under one umbrella of metabolic syndrome leading to this complication. Lack of standard protocol for treatment. There will be various guidelines at the same time. There are various permutation and combination, and these variations may affect the claim. Treatment is purely on management of symptoms instead of cure. Absconding, dropout, or even abandoned by the family members in a hospital will be a challenge. The relapse and remissions of illnesses. Sometimes the relapse may occur within a month or two. Sometimes the illness which had something like psychosis, and then subsequently as a result of getting insight into the illness or because of the pharmacotherapy, patient may land up into depression. So a new illness develops. So this all needs to be taken into account. Next, please. Following the order by the IRDA, private companies have jumped into the mental health sector, declaring about 300 schemes, but these are all not yet translated into all the companies. Most of the insurance mental illnesses are treated on OPD basis, and the expenses for the same are not granted. 0.6% of actual patients need admission. No consideration for ambulance charges, psychiatrists and psychologists fees, which includes their therapies, various kind of behavior therapies, the psychological tests, etc., and of course medicines. Caregivers' presence in mental health establishment with patient. This is mandatory, particularly in case of children, in certain cases with high dependence, where that particular cover is not considered. Government spending on health is hardly any, and the government spending on mental health is absolutely minimum. The out-of-pocket expenditure on health in India is very high. Many people, including persons with disabilities, face catastrophic health expenditure. Though there is a scheme like Swavalamban for them, the health insurance is a promising strategy for them to overcome their burden. Next, please. admission, discharge, and treatment. There are two types of admissions. We have the independent admission. Admission again is patient-centric, as Dr. Gowda said, based on capacity. Now, here the patient will decide the admission. Psychosurgery shall not be performed as treatment of mental illness without obtaining the informed consent both of the patient, caregiver, and the approval of the board. The challenges here are, you need two psychiatrists for certain kind of admissions, and here the consultation cost might increase and subsequently the cost of coverage. Independent or minimal support patient can eventually require full support and rehab, as in case of dementia or de-addiction. Here the cost and premium can differ each time based on the cost and type of treatment. So there must be provision to cover this particular flexibility. Independent patients can exercise their will for admission or discharge, of course, depending on their capacity. However, insurance companies require doctor's certificate to prove admission and discharge. So the conflict between this kind of conflicts, that is the discharge against medical advice or on request, will not be considered. MHRBs will be another hurdle. Next, please. So these are the kind of varieties of treatment which we give for people with mental illness. We have psychiatric hospitalization, we have inpatient care, the residential treatment, which includes even rehab, outpatient treatment, the psychotherapies, varieties of behavior therapies, medications in a variety of pharmacotherapy, the brain stimulation treatments, and alternative treatments or the complementary treatment, like group therapy or other kind of yoga or meditation therapies. Next, please. Now, right to advance directive. Now, this is where the preferred way of care and appointing a nominated representative by the patient with mental illness. Now, the challenges here are the preferred way of care, the premium and the policy bought, they needs to have some kind of tuning. Otherwise, since it offers a great choice of treatment, there will be a higher premium to be paid as per the patient demand. And here the caregiver will have little say. So consideration of appropriate claim management strategies, that is the type and the range of treatment, has to be there. Next, please. Right to equality and non-discrimination as per section 21. Non-discrimination based on gender, sex, sexual orientation, religion, culture, caste, social and political beliefs, and of course, class or disability. Parity in manner, extent, quality with people with physical illnesses. Now, this has to be at par with physical illnesses, so food, infrastructure, ventilation, lighting, hygiene, sensitization, etc. The emergency facilities and services and ambulance services, which are very important. Challenges might be difficult to cover cost at par physical illness owing to ambiguity associated with personality and mental illnesses. As I said earlier, there are certain personalities which we know that such personality may land up with certain kind of psychopathology leading to mental illness. Now, those kind of personalities, though initially have adjustment issues and difficult to handle, they cannot be full-fledged included into this kind of coverage. Clinical syndromes and treatment based on underlying personality clusters, which are we have a variety of permutation and combination for coverage and care for the same. Next, please. Attempted self-harm. Now, this is being considered as per the Act as a stressful condition, as a psychopathology which needs to be addressed. But then, whether the insurance company will take this into cognizance, because the severity of harm varies. Sometimes it may be a minor attempt to gain attention. Sometimes it might be serious attempt. And with all this, the cost will go up and vary between 10,000 to 1 lakh plus. Next, please. Section 23 and 24 talk of right of confidentiality. No personal information or photograph should be provided or released without informed consent. Now, the role of mental health professional here is to intimate that their information is being released to someone else, obtain free and informed consent, explaining the risk, benefit, and alternative. Now, all these medical record and documentation will be going, whether it will be safely handled, safely secured, etc. This will be the challenge, because there will be chances of breach of confidentiality when illnesses and treatment details are provided to these insurance companies. Next, please. We have section 18(4), which is bounding on the government by this statute that various services to be provided with minimum services which are from IPD, OPD services to the rehab services to the varieties of de-addiction centers, child care or daycare centers, then the dementia care centers, the provision of halfway homes, sheltered homes, or supported accommodation. These all needs to be taken into account by the insurance companies. Plus, there are additional services which are in the form of community-based treatment, in physical accessibility close to the patient, all where there is no mental health facility in the government center at particular district. In such a case, the person will be taken to the private psychiatric nursing home, and in such case, it will be reimbursed by the government. Now, how much this particular clause will be accepted by the insurance company is very important. Next, please. The challenges as per the National Mental Health Survey, the demand is more than the supply. We talked of the binding on the government by the statute, but there is enough. Is there any enough staff, enough basic infrastructure, or adequate funds for the same? The lack of private investments in public awareness about mental illnesses. As public awareness increases, greater utilization of the mental health resources, and there will be increased insurance claim burden for the companies. No coverage for substance use disorder. The manipulation of the clinical data that will happen to claim the insurance companies, the insurance. Because sometimes it may so happen during the course of the treatment of substance use disorder, the patient may land up into some kind of medical complications or some kind of psychopathology. And in such a scenario, that particular thing may not have been covered earlier before taking the insurance. Next. Now, this is about the technical aspect of the procedure of underwriting, wherein it enables the insurance companies to decide the amount of cover they can provide under a policy at a rate which is known as premium, which is marketable for them. The insurance provider pulls the data from the actual epidemiological and claim data, which can inform in a comprehensive manner how to approach to assess a variety of pre-existing conditions and its risk impact on future issues. There are international guidelines and standards recommend the communication for the underwriting process for clear, transparent, and made publicly available. As far as India is concerned, this process is opaque. Applicants living with disabilities may be confronted with hurdles which include inaccessibility to insurer evaluations and miscommunications regarding decisions from different stakeholders which involve in the underwriting process. Next, please. So there are certain standards for underwriting processes for mental illness. First, it should be made accessible. It must offer options for modes of communication. It must provide support to the clients who will need assistance with the application. They must sensitize insurance representatives on mental health issues and the appropriate language to be used. The application processes, which includes by being transparent about the process, stress the importance of answering questions accurately and provide the reason for certain questions. Ensure that the questions asked are only relevant and to the mental health issues and treatment. Next week. Communications. be open about the exclusion or the restrictions criteria to mental illness coverage. Clearly communicate to the client the decision for a higher premium or exclusion in case it is necessary. Signpost clients to relevant support services. Regularly review the communications, both verbal and written, with a mental health professional, service user association, and or NGO. The transparency. Regularly update the underwriting philosophy with relevant statistical evidence. Provide clients on their request the evidence used to inform the underwriting decisions for their conditions. Next, please. The Act requires the insurance companies to cover mental disorders on the same basis at par with physical illnesses. And any disparity can be penalized under this particular act and may result in regulatory action against the insurer. So, consideration based on the cost benefit analysis while reviewing the underwriting process. Uncertainty in the ability to accurately diagnose mental disorders. So we generally write the provisional diagnosis and then make certain final diagnosis after certain clinical test or observation. Training of the underwriters for accurate risk assessment of mental disorders. Revision of the underwriting guidelines time and again for appropriate risk stratification to identify standard and substandard risk and their impact on premium charge and coverage offered. The stigma towards the mental illness may in fact discourage the client for going for such kind of policy. The stay in mental health establishment is longer than 2 weeks in case of rehab facilities, which leads to a cost of the policy going up, and of course, which is adding to the higher premium, which will be prohibited to the client. Difficulty for policyholders to select the policy to buy owing to lack of clarity on adequate provisions it has made and the coverage. Next, please. There is a national accredited board of hospitals and healthcare providers. So registration of the establishment to NABH would automatically ensure insurance provisions in addition to quality control of care via audits. However, since Mental Health Care Act also has its own specifications for running a mental health establishment, it has its own inbuilt audit system. The main question is whether we need to get NABH accreditation for coming under the net of insurance companies. Next, please. These are few of the insurance companies which are in India, which are providing insurance coverage in mental health. Apart from certain private stakeholders, we have the Government of India, Ayushman Bharat, PMJ, then Arogya Karnataka, Manipal, Cigna, Pro Health Insurance for their respective state, the Nirmaya Health Insurance for disabled people, etc. Next, please. Now, coming to the professional indemnity insurance. As a medical professional, it's our duty to take care of our clients. Someday we may fail to exercise our duty and neglect promises made, and then we are liable for the loss incurred by the clients. Professional indemnity insurance acts as a kind of safety net which protects us from us and our practice from any financial claims made by aggrieved or the dissatisfied clients or parties. The indemnity claim will cover any legal expenses which will need to defend our status. There are cases where you may not be at fault, and still the clients or their caregivers may blame you for negligence. And thus, this will protect you from any legal charges. If you purchase professional indemnity insurance, it will protect you from such severe actions by covering claim made against you. Next, please. What does the policy will cover? It will cover any kind of indemnity it will provide indemnity against claims arising out of bodily harm or death or any legal suits of any patient caused by or alleged to have been caused by error of omission, negligence, etc. in professional service by doctors and medical practitioners. Not only them, but also their any negligence on the part of their staff also. The policy, however, will not cover any criminal acts, any violation of the regulation authorities regulations, or even the legal provisions regulations. Acts committed under the influence of intoxicants or narcotics. The claims arising out of fines, penalties, or punitive or exemplary charge damages will not be covered under these policies. Next, please. The factors which determine the premium for doctors' professional indemnity. First, of course, is the sum insured. Bigger the sum, higher the premium. The nature of practice. Ours is a practice which we are being watched by multiple acts and regulated by them. We have got, as Dr. Mahesh talked about, the various regulatory bodies also, authorities also, which are coming. So, as a mental health professional in practice, we are at high risk, in a high risk category. The number of individuals covered will also decide the premium. Indemnity limits and the ratio will also decide it. The doctor professional indemnity policy works as per AOI is to AOY limit. Now, this AOI is the maximum claim payable in individual case, while AOY is the total loss covered in a year. The limits selected and the ratio determines the premium of that policy. Next, please. If it is 1-to-1 ratio, that allows the entire sum assured to be used in one incidence, while 1:2 ratio will give only 50% of the sum assured that can be used in a particular case. The size of establishment, so higher the size, higher the premium. Experience of the doctor, qualifications of the doctors, higher the experience and qualification, less will be the premium. Geographical coverage, if you are into, say, kind of medical tourism practice, in such a scenario, being exposed to the international coverage, the premium will be high. Claim history, if you had a history of previous claim for similar, any kind of penal, such negligence or kind of charges, you will have to pay higher premium. Deductible amount selected. So the burden on the policy holder is relatively low in case of higher deductible limit. Next, please. So the takeaways from this about insurance or mental illnesses cover is a fairly new concept in India. Broad or unclear definition of the mental illnesses are the biggest challenge. Changing claims, that is the intensity of symptoms, duration, comorbidities, etc., are the biggest hurdle. Advanced directive and terms of policies. Symptoms of mental illness may vary over time, with original diagnosis no longer valid, causing changes in the course of treatment and prolonging the stay in hospital. It's preferable to have a standardized health insurance product with a tendency for evolution, so that all these things will be able to be taken into account to meet the increased demands. Arranging separate assessment teams with the trained professionals will help in deciding the claim. Next, please. So there is an urgent need for proper monitoring of private insurance companies by social audit and control by a set of authority. Next. Thank you very much.
Thank you, sir. Thank you very much for detailed talk. There are two questions. We will take those two questions. In case if how about non-compliance? How non-compliance will affect the insurance? Like, can insurance company deny in case relapse is due to the non-compliance?
The main challenge here is, in case of non-compliance, if the patient has a capacity. Hello?
Yes, sir. Yes, we can hear you.
If the patient has capacity, in such a scenario, we cannot forcibly treat him as per the act. We cannot forcibly treat him. So where is the claim? Unless the board comes in picture, we take two professionals, we take board's permission to intervene, and then with the application of caregiver, we take board's permission to take this patient into the treatment bracket if he fulfills the criteria for mental illness. Then only we can get the claim. Otherwise, not.
No, sir. I think question was like if patient stops treatment on his own and then he relapses and he is ready to get admitted. So in
So
that
this
case,
sensitization has to be done to the underwriting processes professional, because there are certain areas which needs to be inform them, because these are the areas where we differ from physical illnesses. Like one of the thing, as Dr. Mahesh talked about, abandonment in mental health establishment. Number two, capacity coming back and going again. So these fluctuations in capacity, that issue also, that concept also, so that dependent patient, highly dependent patient with highly dependent needs gets back his capacity, he comes back into independent patient. So these are all these changes, and then once he comes back into independent patient, as a doctor, you might have asked for particular therapy, but then the patient may not accept because his capacity is there, so he may walk out. So all these intricacies of the law needs to be explained to the insurance company people while they're training so far.
there is another question. Those who are running only OPD clinics and their patient needs admission in emergency, will it be negligence if something wrong happened with patient?
See, it's an outpatient department. If it's your first contact with the patient and something happens, first of all, the thing that can happen is because of the antecedent physical illness. If it is to be happen as a part of his mental illness in form of suicidal act, homicidal act, unless and until you have seen the patient, like if he's sitting in my outpatient department and I have not seen the patient, there is no contact. But once he comes in my hospital, he has expressed suicidal ideas, or he has been given input by the caregiver about the homicidal behavior, and I still give treatment on outpatient department and do not admit the patient, then negligence comes on my side also. I mean, I'm talking about the psychiatric emergency. I'm not talking about the medical emergency. Because once the patient comes in, I'm supposed to take care of the physical health also, and I'm supposed to be responsible for physical health also. So if I've known that patient has some medical issues and I've put on paper that patient needs to be referred to so and so particular consultant for this issue, they have to visit that particular, and during that period, if anything happens, we are not. That is my understanding.
Thank you, sir. Thank you very much for this informative talk. Now we will move on to the next topic. We know about the importance of record keeping, since many times we are invited to the court of law regarding legal issues related to our patient. We will try to know in detail about record keeping and certification from our next speaker, Dr. Nimesh G. Desai, sir. Dr. Nimesh G. Desai has done his MD Psychiatry and MRC Psych from UK. He's senior consultant psychiatrist and former director at IBAS Delhi. Dr. Desai is a psychiatrist and qualified public health professional with public service academic career of 40 years, having served on the faculty of NIMHANS, Bengaluru and AIMS Delhi. He served at IBAS Delhi for 23 years, initially as the head of Department of Psychiatry and medical superintendent, and now as a director from 2010 to 2021. He has also been member secretary, CEO of Delhi State Mental Health Authority from 2008 to 2021. He has nearly 100 research papers, many research monographs, and has 5 national awards for original research and many other awards. He has been a Humphrey Fulbright Fellow at JHU, USA, has been honorary general secretary and honorary editor of IPS, has been founder editor of IPS North Zone Journal, 3 times Marfetia Award winner as first author. He works actively with NGOs and in community-based outreach programs, including radio and TV. He is chairman of Ashray Adhikar Abhiyan, NGO for Homeless, president of Manovikas Charitable Society, NGO for Disability. He is also with committees and advisory panels of national agencies like NHRC, NDMA, NCW, and ICMR, and others. He is member of NHRC core group on health and mental health. Uh, I would like to request our speaker to take over.
Thank you, Atul. Can you hear me?
Yes, sir. Yes.
Okay, and you can all see the screen? Please confirm if you can see the slides.
Yes, sir. We can see.
Okay, thank you so much. Quickly, thanks Dr. Umesh, Dr. Dina, Dr. Dhananjay, Dr. Arun, Dr. Balchandra, Dr. Hemant, and finally Dr. Atul. Okay, since we are running late, but I must emphasize this part on this slide, the independent consultant in psychiatry bit. I love that recently. Okay, now, how do I get to the next slide? Wait a minute. Okay, this slide, some or more of you have seen, but I really can't help sharing this slide every time. And our legal issues in psychiatry, mental health practice is quite like this for our country as of now. Let's talk about briefly. There is a huge issue, as we've been discussing in various platforms for the last few years, particularly record keeping and maintaining records. With the workload, with the shortage of infrastructure, staff required, the cost that it adds. And of course, a lot of colleagues are very anguished about, are we really going the American or the Western way of documenting more than actually delivering service? Are we really to be service providers or clerks? And of course, there is this whole issue of record keeping and maintenance in large systems, academic institutions or medical colleges, to small units, general hospital psychiatry units, to nursing homes, to individual chamber practice. And of course, in certification, the issues do flag quickly are whose duty and right is it both ways? Doctors, patients, and right to provide certificate or refuse, or does it operate differently in government, private? And as we know, it does. And what's better, individual opinion or collective opinion? Let's start talking about. Wait a minute, there's something here that I must get out of the way on the screen. Okay, a few disclaimers. Although it was said that we want to talk beyond MHA, some part of what I've been assigned will involve MHA. And so I must clarify that I was not involved in the drafting or revisions of that bill, the MHA 2017, that is now called, except for a few submissions to the Rajya Sabha committee that we did from IBAS and the state government as MHA. One meeting at the Health Ministry, because of another PIL referral process in Supreme Court, where we spoke about specifically what I'm going to refer to in detail, basic medical records. Meetings in the Health Ministry on the draft rules after the act was done. And please, all of our young colleagues must appreciate, while the Parliament does the act, is the executive ministry concerned that frames the rules, like it happened here. And often, many of our colleagues, I think, forget this blur between the law and the rules. And a lot of action actually follows from the rules in accordance with the provisions of the law. I must clarify, I'm neither a supporter nor an opponent to MHA 2017 in toto. What I am convinced about it, it's the law of the land as of now. It's going to take years to even gather experience for amendments, forget repealing or with a new act. And so adherence is a duty that we all have as citizens, as professionals. Now, once straight away move to mental health rules. And like I said, I was party to some of those meetings after the committee that involved some private practice colleagues and demands and ministry officials had formed a set of draft rules. But what's relevant, my friends, is that 2018 Government of India notified 3 sets of rules. One is state mental health rules, unless a specific state revises or drafts its own rules. These rules a state can adopt, as notified by the central government. And then there is, of course, interestingly, a set of mental health care rules that's for CMHA and MHRD. That has forms ABCD, but E also. And some of this I'm going to refer to in detail. And of course, there is the most important mental health care rules, which relate to the rights of persons with mental illness. Now, what's crucial here is that there are these forms that those of us who are involved in inpatient care, private nursing homes, government mental health institutions, or GHBUs, which are now covered, this might be relevant. And so I'm going to refer to this only briefly, not get into the details. But Form A for information on activities of the state authority or board, more importantly, Form B for applying for provisional registration. C, the format in this provisional registration will provide the SMHA to maintain a register in digital form, and there's a format for annual report of the central authority. Those of us interested might get details of this from the web or from the print version. Now, what's relevant for us is this. The mental health care rules actually specify Form A, which is application for basic medical records. As per Rule 6.2, the person concerned, patient, in our case, or the NR has to make application in a specified form. And so to show you a loophole, in case you don't find the application as per the format, you can actually find a way out and say, sorry, the application is not as per format. But Form B is possibly the most important. It's the rules based on the provision in the Act, Basic Medical 425, provide 4 formats. 1 for all outpatients, 2 for inpatients, 3 for basic psychological assessment report, 4 for basic minimum standard guidelines for recording of therapy report. Those of us, if at all we have missed, please register, my friends, that the Act and the rules thereof, as I'm saying here, actually provide for a detailed format for each of these 4. Now, again, I'm not going to refer to Form B 234 because that will be a smaller number of people who might need that. And also, we may not really have time for that. But what I certainly want to focus on is what's applicable to all outpatients. And I'm going to come to details of that. Now, in addition to that, Form C to F, which again, I just want to refer to for inpatient settings, whichever place, GHBU, mental health institution, private nursing homes. And of course, there is a schedule for minimum standard and procedures for mental health care services in prisons, if at all any one of us happens to be involved in that. Now, what's crucial, one part that I want to refer to in detail is this. Please register that beside the 4 formats for basic medical record, what the rules specify, and whether we like it or not, these are the rules as of now notified. So forget the amendments to the law. But even if you want to argue with and do advocacy with the ministry and get some of these rules modified, that action will have to be different. I will keep repeating a few times. While the law was made by the parliament, the rules were made and notified by the Ministry of Health and Family Welfare. And so that's a simpler job. We sometimes forget. What it says, the Rule 6.3 is that basic medical records for all outpatients, and it specifies, I'm quoting it here, inverted commas, to be available when asked at hospitals, nursing homes, private clinics, camps, mobile clinics, PHCs, and other community outreach programs, and the like matters. Unfortunately, I think it also says in hard copy format. It might be easier for any setting, especially individual small clinics or camps, to maintain this in a digital format, as I'm sure my friend Dr. Naresh will talk about, both the pluses and minuses. But this is the rule as of now. The only exemption, my friends, and this is fairly simple in a way. A, name of the MHE or doctor, date, hospital registration number, advance directive, yes or no, is a dicey thing as of now. Name, age, sex, father's, mother's name, address, mobile number. Chief complaints, provisional diagnosis, treatment, advice, and follow-up recommendations. Now, again, for some reason that I don't fully understand or agree with, for outreach programs and camps, this rule seems to exempt I and J. So you can stop at chief complaints. The register maintained at outreach services can stop at chief complaints reported without recording, even in your own case files, or providing to the person when asked, I or J. Now, this is actually about record keeping, one of the most important things. And I'm going to come to what we have debated in our social media and a lot of CMEs in last few months, 1 or 2 years, quite a bit. This law and the attendant rules is only about access to records. It defines basic medical record, and of course the rules operationalize it. Now, what we have not realized, and I don't know really if anyone would like to enlighten later, if any of these states has actually modified any of these rules, because these rules as modified by the Government of India are subject to modification or even complete modification by the state with, of course, the concurrence of the Government of India. So there's a catch there. If a state provides some set of rules which are at gross variance, Ministry of Health, Government of India thinks they might not approve or agree. But one thing is very clear. All mental health establishments and of course psychiatrists and clinical psychologists, other MHPs not specified, must maintain in hard copy these records to be able to provide. Now, yes, neither the law nor the rule have talked about maintaining records. But then listen, for me, as we have said a few times in various platforms, I mean, one can't say that I will provide access to BMR when asked for from my memory. So to me, it does mean and apply the records must be maintained. There can be difference of view about this. We are open to that. But adherence to these provisions and this feasibility is a serious problem, especially in standalone individual chamber practice, or even in outreach services or camps or some of those services that we are part of. But these things are clear. What the positives are, or the mixed picture, at least some positives from these implications are these. In last 15 years, Delhi and a few other states have had a lot of problems of third-party requests for psychiatry records, especially using RTI. One thing is very clear to my mind by the provisions of this law and the rules. Any third-party request for records is clearly ruled out, including any family member. There have been Delhi High Court rulings on this based on IVAS petitions. The spouse, husband or wife or father, son cannot claim to be part of the person unless he or she is specified as NR. So third party would mean anybody other than concerned patient or officially nominated NR. Also under any other law or rule, including RTI. So any one of you in any setting would be perfectly justified, in my view, to refuse any record, any information under RTI, except for, of course, court orders and other such judicial authorities. You understand? There is Commission of Disabilities, there is CWCs, there is the Juvenile Justice Board, and so on and so forth. And of course, you're also obligated under Section 91 of CRPC or whatever is the relevant section of the new law just introduced 2 days ago in Lok Sabha. But please understand, in one Delhi High Court case against IVAS about these issues, the High Court actually upheld IVAS position and said that yes, as per the law and the rules, it will only be access to BMR. The father cannot ask for any other detail. And of course, there were more details about what the team would include. Very quickly, the father had tried saying, the law says only the treating doctor will maintain. Why should the head of the department or director of the institute have access to the records? And the High Court had said, look, a team will involve whoever is operationally involved in the team, including the director or the head of the department. And so that's all right. And you will not ask for anything more than BMR. One must quickly also recall that there have been a lot of IPS initiatives on MHA 27. As most of you senior colleagues remember, the Dr. Vatve Saab's Gail in Bombay High Court suggested amendments to the Act by task force by Professor Indira Sharma and Shruti Srivastav. Very recently, Savita Malhotra and Shruti's and other Mahesh Gowda's survey, of course, with a very limited participation, very sadly, unfortunately, a commentary in press in IJP by Professor Savita Malhotra. But what I double-checked in last few days is that none of the issues, at least that I'm talking about today, or most of the issues that we're talking about today, are covered in any of these initiatives. So that seems to be something else. I also want to caution a few, one about legal provisions in MHA, the other about some pragmatic cautions that I have learned over experience. Please remember, especially our younger colleagues, that Section 23 of MHA actually specifies confidentiality, right to confidentiality of the patient, and again, inverted commas, duty to keep all such information which has been obtained during care or treatment, duty of the healthcare provider, it says. Of course, there are exceptions specified. NR for continuity of care from one psychiatrist to another or one MHE to another. if it is to protect other persons from harm or violence, but only such info, not all info. Only as much as is required to prevent threat to life or protection of other person. Of course, MHRB, CMHA, High Court, Supreme Court, interestingly, seems to leave out SMHA here. I don't understand why. And of course, then it says very conveniently, competent statutory authority. And of course, exemption also for public safety and security if there is. Let me also quickly share here that there have already been in the last 3 or 4 years, 2 complaints to Delhi MHRB about violation of confidentiality. Okay, so it's not something that's in theory or in imagination. There are patients or their NRs who actually object based on Section 23. And of course, Section 24, a quick reminder, is restriction on release of information in respect of mental illness, no photo or any info to media without consent. Practical cautions about record keeping. And this I've learned over 30 or 40 years in a variety of settings, including disciplinary committees of DMC, Delhi Medical Council, or MCI. Please make sure you guard confidentiality of patients unless it's legally unavoidable and imperative to release minimal information, as already discussed. Don't create records retrospectively, even if there's a complication or a legal case or death. Don't modify or change records. Frankly, don't doctor records after an event. Let the records be whatever they are, because that's one of the worst things that can happen for various reasons. As was said, cooperate actively with all the authorities, especially the criminal investigative agencies. And if and when in doubt, seek advice. Never do hesitate to do that. Second part, certification. Now, I have tried saying it in 3 parts, as I have practiced IDBAS and otherwise. One, certification about factual aspects. Somebody is being on treatment, somebody has admitted and discharged. I clearly believe that's a fundamental right of the patient, family, or NR. And so any refusal to provide factual certificate would be actually very thin ice and soft ground. 2, opinions about illness or treatment-related aspects, job-related, education-related, diagnosis. I believe, and the laws, I think, would all in all suggest that the discretion of the clinician, of course, be very cautious about some jobs, public safety and stuff that we spoke about. And then, of course, there can be a lot of requests or orders from judicial or quasi-judicial agencies about competence, divorce, child custody, especially from family courts. That's almost like providing testimony in person as expert witness in a court of law. Now, this I really do believe would be so much better, preferably by a board or a group of professionals rather than individual opinion. If you remember, I had referred to in the very initial slide. There is, of course, a paper in IJP 2022, Alka Subramaniam and a whole lot of other colleagues about disability certification, IPS guidelines, the legal position. So if somebody wants you, please refer to that paper by Alka Subramaniam and others in IJP 2022. Is there a possibility of abuse and misuse of all records, including OPD prescription with diagnosis? Sure, there is. You will remember a whole lot of hospitals, 2 major hospitals that I have worked with, and NIMHANS also, all 3. NIMHANS, AIIMS, and IBAS had this big word, not valid for medical purposes. We are reliably informed that dictum is actually not valid in itself. Any record that patient or family has, any court or judicial, quasi-judicial agency might take note of. Of course, it will be at the discretion of that concerned judicial forum with all the inputs, including expert witness when called for, as to what the final implications will be. And of course, there is a whole lot of civil criminal court reference orders. There is one more aspect, I think, on the next slide that I want to refer to. Some of us might, and I have come across this often in various settings, a request from specific persons or even sometimes relatives to say, doctor, please examine him or me and say, I have no psychiatric disorder, normalcy. A clear no. We do not have expertise for that. We do not have guidelines for that. Court order for certifying sound mind or not of unsound mind. Because unfortunately, again, the newer generic laws will have to examine, but from IPC, CRPC to a lot of some 146 or 150 laws really talk about unsound mind. We have often, High Court, Delhi High Court, and once to Supreme Court said very politely from the Medical Board of IBAS and said, look, we will not talk about or opine about sound mind or even legal insanity. So I differentiate between legal insanity. I don't even like the term biomedical insanity vis-a-vis psychiatric opinion about mental illness and its details. The level of improvement, the current status, and it's a question that the concerned court wants to ask us. Yes, that's our duty, and to the extent possible, that be done. Just to cover this fully, if at all one goes to the court or is asked by a lawyer, by the court or even the opposition lawyer, or either side lawyer as expert witness, try and answer to the extent possible. You also have a right as an expert witness to say no to specific questions, especially if they are opinion-based, if they are speculative, which is very often what the lawyers of either side might do. And of course, certification would always be better, I believe, especially the number 2 and 3 types, number 3 opinion-based, as a part of mental health medical board. And let there not be confusion, I believe, about this. Of course, government mental health institutions and GHBUs or larger medical colleges can have and would have medical boards. But I also believe that some people have started doing that, and nursing homes, psychiatric nursing homes or group practices might actually set up a medical board, either of psychiatrists alone, psychiatrists, mental health professionals, and if you like mental health review board, other inputs. So let's perhaps, I think, start getting into the habit of working as a group for opinions rather than individual opinions or certification. Very briefly, before I end, the issue of disability certification. As of now, it's by medical authority consisting of one specialist and one administrative person or a medical board. Should private hospitals not be authorized, at least after due process of registration and certification? Yes. The law does say that private hospitals can be certified to do so. I am not too sure at all if this has been done. Mental illness related disability by ideas, just to clarify, not just for the 4 conditions that the original instrument specified, but by Government of India notification, all mental illnesses. One notable part, the mental retardation and intellectual impairment part, is done more by law and rules, VSMS. So that's more of social quotient than IQ, for whatever it's worth. And of course, there are specified instruments for autism spectrum and dyslexia, preferably again, the board. I also want to clarify something else here. Please be sure that certification will happen from the hospital or the medical authority, but the rest of the legal process by now is not under MHA 2017. All disability legal processes, including mental illness and other IDDs, happens under the RPWD 2016. And so, to conclude, my belief in last few years has been that whatever was ethical guidelines is now getting codified as law. So let's be sure we adhere to the law to the extent possible, except where you have a professional opinion that prevents you from doing something or opining. 2 major points about each of the 2 subtopics. Record keeping, there are specific legal provisions for access and so implied maintenance of records, as was said, 3 years at least, as per NMC as of now. Recognized fully that it's difficult to implement for OPD and outreach and individual chamber practice, find a solution. The BMR is fairly simple, just 5 items. And besides social demographic data, merely chief complaints, provisional diagnosis, treatment, or advice provided. About certification, follow guidelines where available, exercise caution, especially in contested cases where there is more than one party involved. Always better to have a group or a medical board certifying than individual opinion. I'm going to stop there, Atul, and I hope I have saved some time.
Yes, sir. Thank you very much for that, Chris.
I want to say, permit me this.
Yes.
What I had to say was that, yes, a lot of provisions, including what we have discussed today, actually puts us in a very difficult situation, but we have no choice but to do this.
We will take 2 questions. At the beginning of the first session itself, Dr. Umesh Nagapurkar sir had asked one question.
I arranged the claps too.
That was related to your talk actually. If police asked for the records, not the court, not asked by the court, but police asked for the record, can we give it to them?
See, the thing is this: Section 91 of CRPC empowers the IO to ask for any record with any citizen, any agency. So that's very clear. Whatever will be the analogous provision in the new law now coming into force, but not opinion there. Sometimes what happens is the police will try not to ask you for record, but also discuss, kind of try and say, Nani Daksa, we are just discussing. Verbal discussion, like was said earlier, please cooperate with the police, but please don't provide any formal opinion to the police. What the police and the IU has a right to ask for is records as much as you have. If you don't have something, I don't have something.
The next question is, if I see patient in OPD, so should I keep a separate format for it, or can I take a digital picture of the prescription and store it?
That's the problem. The register, so to say, and I'm really unhappy about this, as I minutely examined this time, the rule seems to say in hard copy format. I don't know why they did that. I mean, at some stages, I was part of post-drafting review of those rules. But yes, I guess in today's world, if you just have a digital register and maintain photocopy of whatever chief complaints, diagnosis, advice given, that should be all right. I don't think any sensible judicial agency would object to that. But if you want to be really, really strictly going by the rules, it will have to be in hard copy format as of now.
Okay, sir. Thank you. Thank you very much for that wonderful talk. Now we will be moving on to the next topic. The world had changed a lot, and everything today is becoming digital. And so, as the psychiatry and psychiatry practice, I would like to invite our next speaker, Dr. Naresh Vadlamani, who will be talking about digitalization and psychiatry. Dr. Naresh Vadlamani is a chief consultant psychiatrist at Columbus Hospital, Institute of Psychiatry, Neurosciences, and De-Addiction, Hyderabad. Associate Professor in Psychiatry, Apollo Institute of Medical Science and Research, Hyderabad. He is ex-assistant professor in psychiatry at Bhaskara Medical College and Kemineni Institute of Medical Sciences. Founder and chairman of Wish to Live Foundation, Hyderabad Suicide Prevention Center. IPS National EC member, South Zone representative from 2021 till date, till 2024. EC coordinator, spirituality, yoga, mental health task force. EC coordinator of forensic psychiatry and law. EC coordinator of human rights and mental health. He is ex-co-chairman of Spirituality and Mental Health Task Force, ex-convener of MSCA 2017 Task Force, ex-convener of Constitution Committee, ex-chairman of School Mental Health Committee, ex-EC member, IPS South Zone branch. There are many in the line. So without wasting time, we'd like to invite our next speaker, Dr. Naresh Vadlam.
I may have that long list of introduction, but basically, I'm not an expert in digitalization or digital psychiatry or technology, nor I'm an expert in legal perspective as well, or law. I mean, we have Dr. Vinod Kunkalni, Dr. Ravish, who have done their LLBs in law and particular to psychiatry as well. I think they are the experts, but I'm not an expert in law as well. Right. So with this brief introduction that I'm not an expert, but I'm still talking. I thank the West Zone branch, the office bearers, Dr. Umesh Nagarpurkar, Dr. Atul, and others who have invited me to make this talk. Right. Thank you very much. Right. So my talk, I'm just giving an overview about what digital psychiatry is and digital health technologies in psychiatry and various legal aspects of psychiatric aspect of law regarding psychiatric services, data protection, use, storage and sharing, intellectual property, taxation laws, commercial agreements, liability and dispute resolution. So I'm trying to speak from the perspective of a legal person. So we have psychiatry, and then what from the legal perspective, what psychiatrists should be aware of and what lawyers should be aware of as well, both. Right. So a brief introduction about what is digital psychiatry. Digital psychiatry is use of technology in psychiatric care to improve efficiency in delivery of psychiatric services and provide personalized care And according to WHO, it defines as a broad umbrella term encompassing e-health, use of advanced computing sciences, big data, genomics, and AI. Right. So, I mean, there's always a talk that what is biological psychiatry? So biological psychiatry, actually, one of my friends said there's nothing called as biological psychiatry. It is just psychiatry. Psychiatry itself is biological. And we discuss about, say, the nucleic acids, genes. We talk about the intracellular pathways involved. We talk about neurotransmitters. We talk about networks. So same thing about digital psychiatry. There's nothing called as digital psychiatry. Psychiatry itself is digital. From the morning when you wake up, when you look at your mobile phone, WhatsApp, some calls, some messages from the psychiatry aspect, from groups, you keep learning. So that is the psychiatry itself. And then you have messages from the patients. You have, say, you do video consultations over WhatsApp or other methods. So psychiatry itself, the moment the patient enters your hospital or your clinic, you enter the patient's name in the computer, that itself is digital psychiatry. So there's nothing called as digital psychiatry, but psychiatry involves completely what is digitalization. So pertaining to these, so I think there are various technologies in psychiatry which we have been exposed to so far. I think every one of us knows the digital diagnostic tools like wearables. You have smartwatches. So I think every one of them have and are monitoring them as well. And they, what is called as, you have different questionnaires where you can self-monitor them as well. So distance monitoring software, hardware, and remote tracing diagnostic tools. We all know about telepsychiatry and telemedicine. I'll tell you a word about telepsychiatry. It was very fascinating term in 2016, 2017, and I did a couple of seminars on telepsychiatry because that was that was considered to be advanced technology, and that's what I thought about telepsychiatry. And I did a paper on telepsychiatry as well, which was published in Indian Journal of Psychiatry. So what it means is that now when I read telepsychiatry in 2019, the article which I wrote, it looks very archaic and it looks very ignorant actually. So what it means, in the last 4 years, the whole practice has changed. So one of the challenges in telepsychiatry was the speed of connection. Every center has to have a laptop or a desktop, and the patient has to visit that place to do the outpatient clinic or consultation from a psychiatrist who is very far off. But now in the last 4 years, we have 5G, the technology has increased so much, the speed, the video consultations have increased so much that you have to accept that you are in your room and the patient is in his house, in some far remote village where there is a mobile phone. He has that mobile phone as well, smartphone. So basically it has come, in the last 4 years, technology has completely changed the pace. So next couple of years, we don't know what I'm talking about. Probably smartphones, when we are talking about smartphones now, but probably after 2-3 years, we will not be talking about smartphones. Yeah. So that is mobile psychiatry as well. And yes, the big data is coming, the AI and the ML, where it is used for not just self-diagnosis, but it has multiple uses across the spectrum. And digital imaging, robotic surgery. I mean, like we have deep brain stimulation therapies are there. Probably we may have that also. Electronic health records. I think we all know that. And the smartphones which are used in big alphabets, the technology. I think that's what is the in thing now, and we know everything about how psychiatry is influencing the smartphones. Through smartphones, how we are getting influenced as well, or we are delivering care, psychiatric care through smartphones.
Excuse me,
Yes,
sir.
there are digital technologies in personal genomics, personalized or precision medicine, biomarker tools, e-pharmacies. So yes, for the last 3-4 years, I think these are the in thing again. Cloud computing, blockchain in psychiatric care. That's where probably encryption and the breaking of the big data comes. So augmented and virtual reality solutions and e-learning in healthcare. I think that's all. We are all using these technologies every day, through and through. So there's nothing called as digital psychiatry. Psychiatry is digital, so that's what it means. So what are the various? So what is called talking about legal, from the legal perspective, sticking to the topic. Do we have digital health or digital psychiatric laws in India?
Excuse me, sir.
Yes, sir.
Sir, can you please raise the volume of your laptop? Some of the participants are saying that
Oh,
the
okay.
volume is low.
1 minute. How do I raise the laptop? Come on. Okay. It's 100%.
Okay, sir. Okay,
Ah.
thank you.
Right. Okay. I'll try to be a bit louder then. Right. Right. So do we have digital psychiatric health or digital psychiatric laws in India? Specifically, we don't have any laws addressing what is called as digital psychiatry or digitalization in psychiatry. So we don't have. So yes, but what we have is we have various laws for various aspects of psychiatric care or psychiatric practice. So I'm dividing that psychiatric practice into say psychiatric services, delivering of psychiatric services. We have different laws. The utilizers of psychiatric services have specific laws for them. We have laws for data protection. We have laws for intellectual properties. We have laws for taxation. We have laws for liability and dispute resolution, everything pertaining to psychiatry. So yes, I mean, the laws, I mean, we have to divide these laws. Whom do they affect? So there are private practitioners, private psychiatric practitioners. There are private psychiatric practitioners who work for corporate hospitals. There are private psychiatric practitioners who work in private medical colleges. We have, say, what is called psychiatric practitioners who work in government hospitals, government medical colleges, and government institutions. Right. So all these laws may not what is called as apply to them, and many of them we need not worry about these laws, but at least we need to be aware of these laws. So that's what it means. So it is like we have multiple thorns, but there are few flowers as well, and that's what we need to wear that. So it is inevitable. The moment we are in psychiatry, we have to wear this crown of thorns, but it could have few flowers as well. Right. So what are these various thorns that we are exposed to or we get? See, I'll tell you one thing, that every day, it is, I'm telling the truth, every day, every one of us, so it's just not the general population, but every psychiatrist as well, we break some law or the other. That is the truth. Let me tell you that. But because law is not implemented, and because it is not known by us that we are breaking the law, ignorant of the law, so that's how the life is going on. So I don't say that we are 100% pure or 100% true. Right. So by making this disclaimer, so let me proceed then. So what are the various laws that we are exposed to and various laws we are trying to break as well, or we are breaking already because of our ignorance? So like someone said, ignorance of the law is not escaping from the law. So that's what it means. So what are the various laws, legalities for delivering psychiatric services? Initially, Dr. Mahesh, I mean, he spoke about some topics. Dr. Nimesh spoke about some topics, and Dr. Dr. Sanjay, he spoke about some topics as well. So I won't be covering in detail. I'll tell you what. So we do have what is called as Clinical Establishment Act of 2010. Yes. So we have several acts or several laws which for particular standards and rules for establishing a psychiatric hospital, psychiatric service, rehab centers, or all which come under Clinical Establishment Act. So there is something called a Shops and Establishment Act, because they think that we are doing some commercial activities. Some or many of the states do think that psychiatric services or psychiatric hospitals come under commercial activity. So they have trade laws and they need a separate trade license as well, apart from the license from the Director of Medical Education or State Mental Health Authority, or say in certain states we need Director of Medical DMHO, we say Medical Health Officer. So we need 3 licenses from them actually. Right. So Drugs and Cosmetic Act 1940 with cosmetic rules in 1945. We need to be aware of these laws as well. What are the various drugs we are prescribing? What schedule they come under? What schedule has certain restrictions? What schedule doesn't have restrictions? So we need to do that. Now drugs, there's another act called Drugs and Magic Remedies Act of 1954 to 1955. We cannot claim that I have invented or discovered some medication that can provide magic remedies. So, and any other, what is called various therapies which claim to have magical properties. So we cannot do that. We need to be aware of those laws as well. And then National Drugs and Psychotropic Substances Act 1985. This is the draconian law, which is people or psychiatrists in Rajasthan and Punjab are most likely exposed nowadays. And I think one of our poor colleagues, he has got entrapped in this law. So one of the things, aspects of this law is that we have to document and register sale of medications. So what are the stock we have, what are the sale, even a single ampule has to be accounted for. So that's the register that we have to maintain. And if there is even a single discrepancy, it is against this law. So then the government has formulated what is called as e-pharmacy rules in 2018, which has made certain aspects that the pharmacy can dispense. Online pharmacies can dispense medications provided the prescription is within the date. So there is an expiry, what is called date for the prescription, and they provide the exact medications as well. And the duration of the prescription, they are supposed to provide the medication. Now, recently, that not just the e-pharmacy, but other pharmacy rules or act has been amended. I think a couple of weeks back or 1 week back in 2023, and we know the certain rules. Now, telemedicine and telepsychiatric practice guidelines of 2020 in March at the advent of COVID. I think these were the appropriate time when the telemedicine and telepsychiatric practice guidelines were released by the government of India, and we know about NIMHANS as well, the role of NIMHANS. Right. Now, Telecom Commercial Communication Customer Preference Regulations of 2018. So one of the rules or laws in this is we can't send messages or in either way, electronically or digitally, to the patients. So without the patients, what is called consent. So that it's like D&D. So that is that if the patients haven't registered that they have to send messages, so we can't send them. So one of these laws is that if we send, there's a punishment for that. Then, we have National Medical Commission Act of 2019, and then every year, there is an amendment, and every time there's a rule that is coming up. And just yesterday, I think, again, we had NMC Professional Ethics and Regulations, which, we say that they have to prescribe in generic way. We have to write medications in generic forms, and many other rules that are coming up by the NMC. Then, and the last and not the least, in the legalities of private practice, psychiatric practice, we have what is called as Consumer Protection Act. Right, sorry. 2019, that is the e-commerce rules of 2020. So medical profession per se comes under consumer protection, and they are the consumers and we are the providers, service providers. So that's the proposed assumption which the law has. Now, in the coming years, so we need to be prepared. So what is called the proposed laws which are coming up is the complete rehaul of the Drugs and Cosmetic Act 1940, including probably the Narcotics Act also will be rehauled as well. And then there will be amendments to telemedicine and telepsychiatric guidelines, and to include allied health workers, mandatory digitalization of health records with compatible technology, and ban ratings-based platforms. I think we all know that there are certain platforms which provide what is called as platform for ratings by the patients and others as well. So which leads to unhealthy competition. And so I think the law is coming up to ban them. Right. So from the patient's perspective, what are the various laws? I think Dr. Ramesh has spoken about a couple of them. Laws pertaining to utilization of psychiatric services, that is Protection of Human Rights in 1993, as well as Mental Health Care Act 2017. So which has laws to protect the human rights of the mentally ill. Now, Persons with Disability Act, that has law has come in 1995, National Trust Act of 1999, which includes the persons with disabilities, say slow learning disabilities, autism, and other psychiatric illnesses. Protection of Women from Domestic Violence Act in 2015, POCSO Act of 12. I think this also pertains to the psychiatry as well. Right. Now about data protection, I think we all are aware of various, probably around 5 years back, we were thinking that we have to have servers in our, say, hospitals, which can store, say, data. So we were looking at the hardware and all kinds of things, but now in between the cloud computing has come up and we can store data in the cloud. But again, we need to be aware of various technologies that are coming up and we need to get updated as well. And particularly data protection of the patient, it is governed by the Information Technology Act of 2000, 2011, rules of 2021. It comes under, again, Clinical Establishment Act, electronic health record standards, what kind of records are to be kept and what kind of protection do they need, as what data can be protected or not, to 2016. And Digital Personal Data Bill of 2022, but it has undergone revision just couple of days back in August 11th. The Digital Personal Data Protection Act was released. Right. So Health Data Management Policy of 2020. DISHA is another the term, like Digital Information Security in Health, particular to healthcare and psychiatric care as well, of 2018. And Digital Security Council of India Privacy Guide for Healthcare of 2021. So pertaining to data protection, there are various aspects of data protection, and these are the various laws that we need to be aware of. Now, legalities in intellectual property. So what it means is, the various components of intellectual property are the patent, copyright, design, trademarks, and trade secrets. So why am I talking about these? Any of the psychiatrists, if we come up with a novelty, with a, say, what is called as an invention, or with a, say, what is called intervention or a discovery in psychiatry, we need to know about the Patent Act of 1970, which defines that kind of intervention as it should be novelty. It should have something new. It should not be what is called as non-obviousness quality. It should be there, and it should serve as utility for the whole population, or the targeted population. So, and if someone has that kind of intervention or discovers that kind of intervention, yes, they can, in psychiatry, pertaining to psychiatry, they can what is called as register in the Patents Act. And then guidelines for computer-related interventions or inventions, of 2017. So what it means is, if we develop a software to help in what is called as delivery of psychiatric services or in any aspect, so there is, we can register that, and it is governed by what is called as Guidelines of Computer-Related Inventions of 2017. And yes, we are protected for that. And then the Copyright Act. So what is the Copyright Act? So this is very interesting a bit. That, okay, computers, we know about softwares and the source code that can have the copyright as well. But there is something called as Clinical Practice Guidelines. Even they can have copyrights. So what it means is that IPS, if it issues guidelines, IPS can go for copyright. And then what are the copyright laws? And if any, say, what is called as any fees can be charged for the copyright, yes, IPS can gain from it. Or suppose any individual or a group of individuals, if they do their own trials, they do their meta-analytical studies, they come up with clinical practice guidelines for something, yes, we can be, and if they pay what is called as register under Copyright Act, they can get the fees for that kind of clinical practice as well. So that's very interesting, actually. Now, Designs Act is another one, so wherein the care, the care is designed in a particular way, and then it comes under the Design Act. Now, trademarks. So you, what is called as, form a logo which is particular to your own establishment, private practice, and that can be registered, trademarks registration, and then yes, no one can use that. And trade secrets. So what it means is, suppose you in a psychiatric practice, right? You employ people, and then you have some trade secrets according to the psychiatric practice, and then suppose that employee or that employed psychiatrist, they would disagrees and then leaves the organization. There is something called as, at the time of joining, this non-disclosure agreements can be made with that particular psychiatrist, and then he cannot disclose what are the trade secrets of one, say, organization to another organization. So yes. Now, legalities in taxation. I think we all know, every one of us pays tax. So we know about the Income Tax Act and the amendment of 2019, and that there is a clause for startups. I mean, if there are any psychiatric startups, there's a tax-free period from state to state. But I think the nation also says that for the first 3 years, you need not pay tax. And then there is huge discussions about Goods and Services Act from 2017. Every one of us knows about ins and outs of GSTs. So I'm not going to discuss about that as well. Right. Now, main laws which pertain to us or which we need to be aware of on a day-to-day basis is legalities in liability and dispute resolution towards the patients, towards the what is called as the consumers of our services and the caregivers as well. Now, what are the suits usually that occur before the civil courts? Is there a breach of contractual obligations between the patient and the provider? And usually the punishment are in the form of fine or damages. So there's no say, prison or imprisonment or as punishment. Now, negligence, as medical negligence and psychiatric negligence also, it is something called omission to do something which a reasonable practitioner would do or would not do in that circumstances or that case. So that is what, again, I think most of Dr. Mahesh Gowda has already pointed out a couple of cases of negligence and breach in duty of care. So what treatment that we prescribe to the patient, and we need to make sure that it is administered, that treatment is administered. And if it is not administered, then it also comes under negligence. Now, what is vicarious liability? The vicarious, if an employee does what is called a medical negligence. Suppose a psychiatrist is employed, he's given a salary by the organization, and he does what is called medical negligence or any other case. Vicarious liability is the employer also is liable for that, right? But as in suppose corporate hospitals, usually if the psychiatrist is on call or if he's an independent contractor to the service provider hospital, so the service provider is not liable for that. So whatever the medical negligence the independent contractor does or independent psychiatrist is doing on call. Right. Now again, the Consumer Protection Act, disciplinary action by NMC. So these are again the laws. I mean, what is the disciplinary action? What are the pathways? Is the first, there is a warning or a punishment by the state medical council. And if the agreed psychiatric practitioner says that he's not satisfied, then he can write to the Ethics and Medical Registration Board within 16 days, within 60 days. Now, after the after the after the Ethics and Medical Registration Board, if the psychiatrist is not satisfied, then he can apply to the NMC, that is National Medical Council, again within the period of 60 days. Right. And then the criminal liability laws, any sections of IPC 1860 and its amendments further, I think we all come under that. So I think we need to be aware of all the criminal liabilities. So trying to what is called conclusion, it's tale of 100,001 arrows. So what it means, what killed Bhishma, what we say is that not the thousand arrows, but probably the last arrow. Right. By Shikandin we say, but yes, it's the last arrow, and the last arrow is Mental Health Care Act 2017. So every practitioner is so much dreaded by this act, right? We have having discussions for the last 6 years, 5 years, every conference and everywhere we are discussing about it, but still we are not finding any answers. So I will not go into depths of these. This has been what is called discussed in the past several times. Right. Yes. So what do we want finally? So after all these legal or all the legal aspects of psychiatric practice, and because it is digitalized in every way, we want amendment of MCA 2017, laws that match with rapidly changing technology in psychiatry. Yes, specific data protection laws pertaining to psychiatry, unified electronic health records, regulation of e-prescriptions, standardized hardware and software across devices. Patients are no longer consumers, they are co-partners or co-deliverers. So what it means is that there is input forms. So before coming to the hospital or before coming to the psychiatric practice, there are certain forms which the patient himself can fill regarding what he is suffering from, what complaints he has. Right. When he does that, it facilitates the doctors or psychiatrists to what is called reduce time and diagnose. So when the patient himself is filling that, so he is no longer a consumer, he becomes a co-partner as well as co-deliverer in healthcare. Right. An NMC code and ethics to match digitalization in practice by psychiatrists. And finally, there is something called as a big thing that is coming up, which is Ayushman Bharat Digital Health Mission, which is something like a tsunami or what we say in Telugu, we say Timingalam. Timingalam is a whale, so it will swallow everything. Like. So I think this will try to swallow everything that comes under it. So what does it involve? The Ayushman Bharat Digital Health Mission involves health data management. And there's something called as health data management is whatever data is being fed. So there is something uniformity across the country, and the health data is what is called goes to a centralized healthcare storage, and that is one. There's another facility about Ayushman Bharat Digital Health Mission is called Sandbox Facility. So what is the Sandbox Facility is every private practitioner or wherever technology in not just psychiatry in healthcare is what is called invented or discovered or any software, everything, it has to be submitted to this sandbox facility so that it is compatible across India. So it is tested here whether this technology, whatever that new technology is invented, whether it is compatible with technology which is already existing across India. It is like if you say the C charger. So I know every one of us have chargers, but now the C charger is what is called uniform across mobile phones, which is otherwise, I mean, in the past, every mobile phone had their own charging pins and all, which we can't use for other mobile phones as well. So I think something like that. So it should be compatible with every other facility which is existing. And there's another big thing called a unified health interface. It is like something called a unified payment interface, where the moment you produce your Aadhaar card or your health card number or so whatever number is given, it is automatically what is called entered into the database. So you buy a medication, you require this number. You get investigated, you have to produce this number. So what is called as I mean, you go into a hospital, you see a doctor, you need to produce this number. So it is something like your Aadhaar card or ID card. So it is you have to utilize it everywhere so that you can be what is called as traced or your whole health data is being retained. And health data retention, usage and storage as well. So that's what this digital health mission does in digital form. So in conclusion, what it means is that laws cannot match the pace at which digitalization and technology are adopted in psychiatric practice. Right. So psychiatry is moving, or digitalization in psychiatry is moving at a fast pace. Laws cannot match it. And we are always at the disadvantage place. And I mean, we have to accept the technology, and we will always be, the laws will always be behind us. That's what it means. And insurance companies will be playing a big role. Probably, I mean, even private practitioners will need to come under insurance companies. And then probably the data management can be done by the insurance companies, will be protected by the insurance companies. So even if there's a data breach, the insurance companies will be liable for that. And individual doctors will not be liable for that. And yes, Ayushman Bharat Digital Health Mission will be a game changer in the future with necessary laws to match it. Thank you very much. Hello? Yeah.
Hello.
Hello. Yeah. Are you able to hear me?
Hello.
Thank you very much, sir. I think someone. Okay. So before we move to the question answer for this session, I would like to request participant to stay till the end because we have two announcements for you all. Sir, since there is no question
Sir,
in the
sir,
chat
one
box.
question is there. Sir, I have a question, sir.
Okay, you can ask, sir.
Sir, as sir said that laws cannot match the digital advancement in the digitalization of psychiatry. So since laws cannot match, the speed is variance. So does it mean that it is breaking the law is easy for us?
No,
Because it will not come under the preview of the law. So there we can take the advantage of that speed difference, I think, sir.
It's not like we will take advantage. Usually what happens is when the case goes to the court, the judge will try to interpret it in his own way. Now, suppose his wife did not make filter coffee that morning and gave him brew instant coffee, so the judge will put the case against us, right? So it depends upon the judge how he wants to interpret. So that we are always at a disadvantage and at the what is called mercy of the judges, if it goes to that extent. So that's what I wanted to say.
Okay, thank you so much.
Sir, I would like to ask one question. Like there are many platforms like Librate, Practo, and all. So indirectly, they try to solicit the patient for those who pay higher charges to them. So what is there any law regarding that? Like,
So as of now, there's no law. There's just rules are there, but then laws are coming in the future to ban those.
okay. Thank you very much, sir, for this wonderful lecture and information. With this, we are coming to the end of this program. I hope you enjoyed today's sessions and had collected many new learnings for present and future. I would like to thank our IPS West Zonal Branch and Legal and MSCA Committee. I would also like to thank Dr. Umesh Nagapurkar, sir, President, Dr. Nina Sawant, Madam, Vice President and President-elect, Secretary, Dr. Dhananjay Asturkar, sir. I would also like to thank Dr. Arun Marwale sir, for who is a chairman of legal committee, Dr. Bhalchandra Kalmek, who is convener of legal committee, Dr. Hemant Sonani sir, for who is EC coordinator for legal committee. We'd like to thank all the speakers, Dr. Sanjay Kumar sir, Dr. Mahesh Gowda sir, Dr. Nimish Desai sir, and Dr. Naresh Badlamani sir. I would also like to thank person who helped with technical things so that this program ran smoothly without any technical glitch or problem, Mr. Yogendra. And most important, thanks to all the participants because you joined in spite of it being Sunday today. And also thanks to your family who allowed you to join. Thank you once again. So two announcements that I would like to make from the IPS West Zone branch. One is that we have recorded this session and you will get link of this. We will upload it soon on the our YouTube channel of IPS West Zone branch. You can access these sessions there with due permission of the speakers, of course. The second thing is we know that there are many things that are left because of time limit. MSCA is coming, committee is coming with the second season in the next month. We are planning for the second program on the same topics or the related topics in the next month, that is September. So stay connected. Uh, So see you there in yet another similar program. Until then, goodbye. Take care. Thank you, all the speakers. Thank you all once again.
Yeah, thank you all.
Thank you.